Now we're going to move on to another bill. It is PCSMB for CS, for HB 835 and HB 947 by Rep. Byrd. We'll have a lot of people that want to speak on this bill, and we want to hear as many people as we can, but we are time constrained, members and visitors. So we may need to limit how long people talk. I'm going to ask the members to keep your questions concise, your debate to the point. I'm going to ask the guests and representatives to try not to be repetitive, but we will try to hear all of you. We may need to limit the time, but we'll get started now. And Rep. Byrd, you're recognized to explain your bill.
Thank you, Honorable and Illustrious Chairman Masulo, members of the committee. Good morning. You did mention that this is a PCS for MB, which means Preferred Committee Substitute, multiple bills. And so what the PCS does is it combines House Bill 835, which is my bill, with House Bill 947, with Representative Plakin's bill. And the reason this was done, as this is what was done in the Senate with Senator Baxley and Senator Rodriguez's bill. So this PCS now lines up with where the Senate is on this issue. Members, Florida's Constitution and laws provide workers with two basic rights: the right to work and the right to collectively bargain. For decades, the legislature has repeatedly worked to refine our laws so that these two basic rights are balanced and respected. This legislation is the latest effort. The bill requires an employee to sign a membership authorization form when they join a union. The membership authorization form must include a statement that the employee understands that Florida is a right-to-work state and union membership is not required as a condition of employment. The acknowledgement must include a statement that payment of union dues is voluntary and the employee may not be discriminated against based on union membership or financial support. It requires a union to revoke an employee's membership upon the employee's written request. If the employee is required to complete a form to request revocation, then the form may not require a reason for the employee's decision to leave. Once again, the union can ask, but they cannot be required as a condition. Prohibits union dues and special assessments from being deducted from an employee's salary by the employer. However, public employees may pay their dues and uniform assessments directly to an employee organization. It revises the information and documentation required to be submitted by an employee organization in its annual registration renewal application. Similar to what a K-12 bargaining agent must submit today, the bill requires employee organizations to include in its annual registration renewal application the following: the number of employees in the bargaining unit who are eligible for representation by the employee organization as of December 31st of that renewal period, the number of employees who are represented by the employee organization as of December 31st of that renewal period, specifying the number of members who pay dues and the number of members who do not pay dues. Documentation provided by the public employer verifying such information, and documentation provided by the public employer verifying it was provided a copy of the employee organization's registration renewal application. The bill requires an employee organization to petition the Public Employees Relations Commission, PERC, for recertification if its dues-paying membership drops below 50% of the employees eligible for representation. Finally, the bill specifies that the provisions of this bill do not apply to an employee organization representing law enforcement officers, correctional probation officers, or firefighters. That is the bill, Mr. Chairman.
Very good. Having explained his bill, we'll start with questions. Rep. Hardy for question, and then Rep. Nixon. And we'll move down the line. Rep. Hardy, you're recognized.
Thank you, Chair. What is the purpose of disallowing the payroll deductions for union dues?
Sure. So the genesis of Mr. Chairman, thank you. So the genesis of this arises from the Janus opinion from the United States Supreme Court in 2018, which says that the employees have a First Amendment right and that the union cannot speak for them. When we're talking about dues deduction, that is public funds, taxpayer dollars. And so while the bill does nothing to prohibit a public sector union from engaging in political activity, they cannot use the private or the public employer to be their dues collector.
You're recognized for follow-up.
Thank you, Mr. Chair. Didn't Janus have to do with agency fees? And are there any unions charging agency fees here in the state of Florida?
You're recognized.
Thank you. So you are correct. In the Janus opinion, that dealt with the state of Michigan, which was dealt with agency fees, which we do not have in Florida. But the policy consideration is still the same, that we do not want, or we want to disallow the public, who the taxpayer, to collect the union dues on behalf of the union.
One more follow-up, go ahead.
Sure. Why doesn't that logic apply to police and fire unions?
Thank you, Mr. Chairman. It's a great question. It's a policy preference that we've decided that police and fire have a unique role in the public sector. These are individuals who run into danger, not away from it. And so we are making the policy decision that because of that unique role that police and fire play, that they can continue to have the dues collected.
Rep. Nixon for a question.
Thank
You're
you,
recognized.
Thank you, Mr. Chair. Hi, Rep. So I want to kind of go down that line of questioning in regards to danger. So some of the public service workers are, janitors and custodians are janitors, bus drivers, teachers, and we're just coming out of a pandemic. Are you saying that they don't deal with danger and they shouldn't be excluded from this as well?
Thank you, Mr. Chairman, and thank you, Representative, for the comment. And I'm sure you can file a bill next year to include them, and if you think that is the situation. But I don't think anyone would say that other public sector union employees face the same risks on a daily basis that our police and fire men and women do.
Rep. Bartleman for a question. You're recognized.
Yes. So you're saying that risk should be the sole determination on whether or not someone has dues deducted from a paycheck?
You're recognized.
Thank you, Mr. Chairman. No, not at all. That's not what we're saying at all. This is a policy preference, a policy decision that the Senate and House have made that police and fire face special risk, and that is the reason they're being excluded.
You have a follow-up?
Yes. Would you acknowledge that bus drivers on the road have risk? The teachers who held down their students during the mass shooting at Marjorie Stoneman Douglas and sacrificed their lives and died had a risk?
Rep. Bartleman, I believe that was asked and answered.
Well, I was bringing up the points where where teachers really are at risk, and it is actually life and death. They put their lives on the line and died, just like police officers and firefighters. So I just wanted him.
I don't think he denies that it was asked and answered.
Okay, thank you, Chair. Can I
Actually,
ask one
point
more
of
follow-up?
clarification, Mr. Chair.
You're recognized for a follow-up, and then Rep. Joseph. I'm sorry, Rep. Hinson, then Rep. Joseph.
Okay.
Well, it was
You
for a
recognize for a
question.
follow-up.
I'm sorry, Mr.
Okay,
Chair.
I'm sorry. Okay. I also did. Let me ask the question so I ask it exactly how I need to do it because I'm very emotional. Why do you think it's necessary to change this law? Like, what complaints have you had that you think that we need to rebalance all of this and then exclude certain groups that are predominantly jobs that are held by women? What complaints have you heard?
You're recognized to answer.
Thank you, Mr. Chairman, and I think that's an outstanding question. I appreciate it because I can tell you specifically that, in my community, House District 11, I have policemen, firemen, teachers, and other types of union members. I don't have my friends that are policemen and firemen complaining about their union. I do have my friends that are teachers complaining about their union, and primarily the complaint is the political activity they engage in. They engage in issues that far go beyond the issues of the work environment and pay and benefits. They go into issues. I have friends that are teachers that are pro-life. Some are pro-choice. Some are pro-gun. Some are anti-gun. Some are so on a range of issues. The unions are engaging in very political activities, which they have every right to do. What they don't have the right to do, and what I want to make sure before the speakers come up to make sure that everyone on the committee knows, is there is no right to have the taxpayer be the dues collector for the union. The union can do that on its own. We live in a digital age. In which we all can pull out our phones, and in a matter of seconds, I can transfer money to any one of you. This is not a burden on the union. And what I suspect, actually, is that what the union fears the most is that if they actually had to have the dues collected every month from the individuals, then maybe the individual members in that union will start to question and say, why are we engaging in certain activities? You do not speak for me. And I think that is the conversation that the union is afraid of.
One more follow-up,
That's it.
and then we'll move on to some other members.
these are not the only deductions that come out of paychecks. You have insurance deductions, you have sometimes nonprofit deductions. And you have to admit, I mean, insurance companies are one of the biggest lobbies up here. And the money collected from insurance companies are used to lobby for these same people who always have complaints and everything else. So why allow those deductions as opposed to others?
You're recognized.
Thank you, Mr. Chairman. So on the issue of dues deduction for, say, a charitable organization, that's not political activity. Having, in the last committee, it was brought up that some teachers have their gym memberships deducted or their United Way contribution deducted. That's not political engagement, and that's what Janice talked about, was the First Amendment right of teachers, or public sector union employees, to engage in First Amendment activity and the union to speak on their behalf. So it's the policy decision that if the union is going to engage in those activities, which they have every right to do, that once again, they do not have the right of the taxpayer to deduct the dues for those specific purposes.
Thank you, Chair.
Very good. Rep. Henson, you're recognized.
Thank you, Mr. Chair. I do get overlooked and ignored a lot. Thank you for recognizing that I was next.
Yes, ma'am.
Representative, when you were addressing Rep. Hardy, you mentioned we this and we that. Who are the we that you're speaking of?
You're recognized.
Thank you, Mr. Chairman. And Rep. Henson, I mean, I know from the last committee that you've made no secret of your disapproval of this bill, so I fully acknowledge that. I will not get your support today, and you will be not one of the we, but I do think that we have the votes on the committee to pass this, and I do believe that when it comes to the floor in the House and the Senate, that it will be passed. That is the we.
Okay, so can I get my question answered?
Rep.
So
Henson,
the
yes.
we
Rep.
are...
Henson?
I'm sorry.
Henson. We'll try to not be personal here.
I didn't. He said we.
Very good. You're recognized.
I was trying to figure out who the we are. So I want to answer my own question, maybe?
Well,
The
you don't have to
we
do
are
that.
the members of the committee that agree with your bill. So I have some other questions, Mr. Chair.
You're recognized.
Thank you. Do you believe the policies in this bill may be a violation of the Equal Protections Clause of the 14th Amendment?
You're recognized.
I do not, but I wouldn't be surprised if that challenge is made if this bill becomes law.
It will. So do you believe that by excluding fire, police, and correctional officers, which statistically is a predominantly male profession, and requiring other professions such as teachers and nurses, which statistically is predominantly a female protection, creates a disparity that may be considered gender discrimination?
You're recognized.
Thank you, Mr. Chairman. Absolutely and unequivocally not. Yesterday we had on the floor Representative Davis from Jacksonville, had a police chief on the floor from Jacksonville Sheriff's Office who was a black female. There are many women who work in police and fire. In fact, my aunt was a captain in the Jacksonville Fire Department, so there are many women who work in these professions. So I do not think it has a discriminatory impact on women.
We'll see that in the challenge as well.
Rep. Henson,
I'm done.
please.
Thank you, Mr.
Rep.
Chair.
Joseph,
for-
you're
Thank you,
recognized.
Mr. Chair, for enduring.
You're welcome. Rep. Joseph, you're recognized for a question.
I'm not sure where to start. So your position is because there was a black female chief on the floor yesterday in the House, that is the reason that there cannot be a disparate impact on professions that are predominantly female versus predominantly male, and by predominantly male, defining the ones that were excluded in the exception, fire, police, corrections versus teachers, nurses, and other public employees that tend to be predominantly female. You cannot acknowledge that there's a potential for disparate impact there under the 14th Amendment Equal Protection Clause?
Rep. Joseph, I believe he answered that question.
No, because the question I just asked is the reasoning for his
So you're asking
answer.
for the reason?
Yes.
Very
The question is the reasoning that he's just identified that there was a black female chief on the floor yesterday, the basis for saying that there's no place for equal protection, a disparate impact claim.
You're recognized.
Thank you, Mr. Chairman, and I reject the premise of your question, Representative Joseph. I was using that as an example to Representative Henson's question, commentary on the fact that some suggestion that women are not engaged in the police and fire activities. What we're dealing with, and when you read Janus, of course there are unions that have predominantly more men, or be more male or female, but this doesn't go to their first. This goes to the First Amendment right to speech, and nothing is changing with regard to their ability to engage in political activity and speech.
You're recognized for a follow-up, Rep. Joseph.
Thank you, Mr. Chair. I'll get to the First Amendment right to speech, the right to assemble, the right to petition your government, but right now I'm focused on just the 14th Amendment, Equal Protection Clause, as it relates to a potential disparate impact. Acknowledging your question that some professions are predominantly male or female. My question is, for your bill, do you see, I think that part is clear, because I think is it true that you're anticipating a legal challenge based on the disparate impact claim, a disparate impact claim?
You're recognized.
Thank you, Chairman. No, it's my experience being up here long enough that anytime there's a controversial bill, we get threatened with lawsuits, and we're not going to not do the right policy because of a threat of a lawsuit.
Okay.
Very good. Rep. Woodson. We'll go to Rep. Woodson. We'll have to get around here, members.
That's
Otherwise,
fine.
people aren't going to get an opportunity. Rep. Woodson, you're recognized for a question.
Thank you, Mr. Chair. Well, Bert, I had a few questions, but some of them have already been answered, been asked of you. But I want to know, because I'm sitting here, teachers, when it comes to teachers, I try to do my best in order to make sure that our teachers are covered, because we all, like I mentioned earlier, we all are here because of our teachers. And I know those union members are made up of the same taxpayers, the teachers, and so forth and so on. Can you please tell me, do you feel that we are sending a message that we are single, when we're trying to focus on one payroll deduction for union members? Do you think we're sending the message that we are singling them out?
You're recognized.
No.
Do you have a follow-up, Rep. Woodson?
Okay. Thank you, Robert.
Ranking member?
Yes,
Oh, I'm sorry.
Yes, Mr. Chair, I have one more question.
All right. You're recognized.
Do you know how many payroll deductions currently exist? How many payroll deductions do they have roughly? Do you have an estimated number?
You're recognized.
In any individual bargaining unit, in any individual, I don't understand what you're talking
Any
about.
individual bargaining unit for this, yeah.
You're recognized to answer.
Thank you. I don't understand. I don't really
Rep. Woodson,
understand.
can you rephrase the
What I'm
question
saying,
to a specific topic?
how many payroll deductions currently exist in any individual union?
You're recognized.
I don't.
You don't have that number?
Rep. Woodson,
All right, thank you, Mr. Chair. Thank you.
very, very good. Thank you. All right. Ranking Member Smith, you're recognized, sir.
Thank you, Mr. Chair. Thank you, Chair Byrd, as well. I know that obviously I saw the bill in a previous committee, so you know where I stand on the legislation. I'm hoping we can have a discussion about the PERC part of the bill, and hoping you can maybe help educate us on what the process is that PERC goes through, but my specific question about how the bill impacts that process, I was hoping you could maybe provide some specific examples for us of where there have been problems or issues that arise that would, I suppose, justify the additional PERC authority or require the additional PERC authority that your bill is seeking.
You're recognized. Thank you, Mr. Chairman. And so the issue of PERC came up in the Appropriations Committee. And so what we currently operate under the honor system, in which the union says this is our number of dues-paying members in the state, or the governmental entity, the public employer just has to accept that. So what we are doing is we're using PERC to verify that employee who wants to be a member of the union actually wants to be a member of the union. So it's just a part of a verification and transparency.
Follow up, you're recognized.
Thank you, Mr. Chair, and thank you, Chair Byrd, again for the answer. I guess help me understand, since we're merging your bill with Rep. Plakin's bill, which we heard as separate bills in the previous committee, so maybe I just need to reset my understanding of what the two bills do. But you're referring to the PERC confirming in some way that the employee has authorized the deduction. Are they not already providing that authorization under law? Is this one of the additional authorizations on top of authorization? Because I remember it was really repetitive in Rep. Plakin's bill, so I'm trying to distinguish that from what you have prescribed in your bill.
You're recognized.
Thank you, Chairman, and I know that you had issues with Representative Plakin. I remember the colloquy quite well. But no, those parts of it have been taken out because since we have removed the public sector employer as the dues collector, we no longer require that, but the union is still required to provide information to PERC, verification of the number of dues paying members and the members in the bargaining unit. So we took out some of the, I think what you would call the redundancy or repetitiveness of Representative Plakin's bill, and because we have the paycheck protection, that was no longer necessary.
I'll give you one more.
Thank you, Mr. Chair. Thank you for acknowledging my illustrious question asking. So just trying to understand, I want to make sure that PERC has the resources that they need to do this. Do you think we're going to have any issues related to additional appropriations? Can they do this additional oversight? Can PERC do this without an additional budget authorization, or do you think we need a new appropriation?
You're recognized.
Thank you, Mr. Chairman, and this came up in the Appropriations Committee. So, yes, there is a fiscal that will come from trust fund money. There will be no general revenue monies available. The trust, there is the money in the trust fund. And I know at the last committee stop, the argument was made that, oh my gosh, this money could be used for books and computers and a whole host of other things. The money in the trust fund cannot be used for that. It is only for PERC to do its statutorily authorized job.
Very good. Rep. Nixon, you're recognized for another bite at the apple.
Thank you, Chair. I have a few questions. So,
Let's do one at a time.
Going down that line of questioning in regards to political activity, don't federal laws already prohibit dues deductions for political purposes?
You're recognized.
Thank you, Mr. Chairman. I mean, yes, but money is fungible, and the union still engages in that, and nothing stops them from doing that, except instead of using the public employer to be the dues collector, the individual union member will pay the union directly to engage in the same political activity that they can currently do now.
Okay. Another follow-up question. Don't police and fire also engage in political activity?
You're recognized. Can you rephrase your question to be a little more specific?
No, because the sponsor of the bill stated earlier that. Let me rephrase. Oh, don't the police unions and the firefighters union engage in political activity as well as like giving PAC checks and things like that?
You're recognized.
I haven't looked at your finances, Representative Nixon, so I don't know with respect to you. But I'm sure that police and fire engage in political activities.
Okay.
One more question, Rep. Nixon.
And in regards to other organizations that may do dues deductions and things like that, like United Way, hospitals, all those type of groups that, oftentimes take out dues deductions, do they employ lobbyists that engage in political purposes?
And you're recognized.
I'm sure that they do.
All right, we'll go to Rep. Hardy now.
Thank you, Mr. Chair. I wanted to follow up on a question by Representative Bartleman that was not answered completely. Representative Bartleman brought up insurance companies, and your premiums are often deducted from your payroll And insurance companies engage in political activity. We're lobbied by them on an almost daily basis. And so I'm wondering, do you not care about the political activities that employees may object to, that their insurance companies fund with money from their premiums?
You're recognized to explain that.
Well, what's great about the union and the membership is that they can go to their union and make a change in their insurance provider if they so choose. So they will continue to have that ability to do so.
You're recognized for follow-up.
Well,
Well, then just redirect it for him.
I would just like an answer to the question that I asked.
Can you rephrase the question?
I don't believe that I need to because it was phrased in English, but let me.
Hardy.
Mr.
Okay,
Chairman,
Hardy. Hardy.
that line of question, that is personal and it's out of line, and I object to Representative Hardy making that statement.
Point of clarification, Mr. Chair.
Rep. Hardy, Rep. Hardy, I'll let you rephrase your question in a more professional manner, please.
Your stated reasoning for having issue with union payroll, union dues deductions from payroll is that certain unions engage in political activity with money that is apparently not from the dues, but with money that's fungible, and that only those union members complain to you about the political activities of their unions. And so if political activities that may be objectionable to the worker who's paying them through a payroll deduction, if that is the source of your concern here, why doesn't your bill extend to other payroll deductions where that money is being used to fund political activities that the workers may object to, such as insurance companies? I would like a direct answer, please.
And you're recognized.
That's an answer, Mr. Chairman.
All right. Rep.
Mr.
Hardy,
Chair.
Rep. Hardy, that was his answer. I mean, you might not like the answer, but that's the answer he gave you. Rep. Bartleman, you have another
Yes.
question? Go ahead.
Yes. So you said you're doing this because you got some complaints from teachers about the political activity. You didn't get complaints from firefighters and police officers who have that same political activity. How many calls, emails, and texts have you received in opposition to this bill? Because I have hundreds from Republicans, independents, and Democrats, and all people who live in all of our districts. So how many have you gotten?
You're recognized.
Thank you, Mr. Chairman. Well, I reject the premise of your question. I didn't say that this was the only reason that I brought the bill. The primary reason is the Janus opinion, and that this is something that this legislature has been working on for many years prior to you becoming a member. So I said it was one of the reasons that I had received complaints. To an answer to your question, not the only reason. I've received many emails for and against this piece of legislation.
I'll let you do one follow-up, but let's move to something a little different.
I will. And Chair, thank you.
One follow-up.
I'm not a lawyer because I was a teacher. Very proud of that. That doesn't have to do with what we're talking about here. I know you keep bringing that in, but I've spoken to other attorneys. We're a right-to-work state. It had to do with something else. So can you please explain to me how our specific state and what we have going on here, you can draw that comparison from that opinion?
You're recognized.
Thank you, Mr. Chairman. And I was a public school teacher, and I'm a lawyer, so I think I'm highly qualified to answer your question. So the Janus opinion, yes, it was different. The situation in Michigan was different, but that does not mean that the First Amendment foundational principles that were addressed by the majority in Janus are not applicable to other states and other factors. And Florida is not the only state that is doing and following on the heels of the Janus opinion in 2018.
All right. Rep. Chambliss, and then we're going to move on to the amendment first.
Greetings, sir. How are you today? My question goes back to what you were mentioning about the preference to exclude the police and firefighters from this particular effort. One of the main things, one of the things that I remember you saying was that it was due to the danger that's involved in their job, the risk, right? After going through a year of a pandemic, would you do you think that our nurses, just as an example, specifically now, would fit that category as well, being that they place themselves in harm's way to deal with a situation that none of them had any prior experience to, therefore risking their lives? Would you say that at least in the last year, they were in a similar situation to our law enforcement and our firefighters?
You're recognized. Thank you, Vice Chair. Yes, other employees and professions have been at a heightened risk during the pandemic. That is not the same. On the day in and day out, year in and year out, risks that our police officers and firefighters face. And that is the reason for the policy difference.
One follow-up.
One follow-up, but he's answered that question a few times now. You're sort of beating it. Do you have something different?
Yeah, but he gave a different answer this time because he said yes, based on the pandemic. He said yes.
You're recognized for your follow-up.
And so, being that you acknowledged, the danger that they just faced over the last year, did you give any policy consideration to also excluding them from the premise of this bill based on the fact that you acknowledge that not only did they face danger, but remember, the pandemic isn't over. And so we don't even know what the future holds. And so did you give any policy consideration to them as well?
You're recognized.
Yes.
All right, we'll move on. Rep. Whitson, one question, please.
Thank you, Mr. Chair. Thank you very much, Mr. Chair. Rep. Byrd, I have one simple question, actually, because I noticed there are some unanswered questions, and also there's a lot of tension. It's obvious. I have one question. What is the intent of this bill? What are we trying to accomplish? Why are we making it a little more difficult for public employees? That's my only question.
Rep. Woodson, he explained the intent of the bill during his initial presentation of the bill. Do you have a specific question for him so he doesn't have to repeat what he said before?
It's still unclear to me. Yeah, Chair Masulo. I'm sorry.
All right.
I can answer it, Mr. Chairman.
Recognized.
Yeah, listen, I fully acknowledge that there is a policy difference on this committee and in the legislature over this issue. That's I acknowledge, and you will have your opportunity to vote yes or no on the legislation. But I've explained repeatedly, and I reject that I've not answered the questions. You may have not have liked the answers that I gave because you don't like the policy, but I reject that I've not answered the questions. But the policy here is in line with the United States Supreme Court opinion in 2018 that we have an obligation to ensure that we are a right to work state, we are a right to union state, and to make sure that those two competing rights are balanced. And the policy preference is to use this legislation to ensure that that happens.
Rep. Hinson, you're recognized for a question.
Thank you, Mr. Chair. I'm going to try and de-escalate for you a minute. You say the $400,000, oh, by the way, there was an analysis of this bill. It's going to cost taxpayers $400,000. And you say it's coming from trust funds. Can you tell me which trust fund?
You're recognized.
The PERC Trust Fund.
I'm sorry, did you say PERC?
PERC.
P-E-R-C, PERC.
I thought you said PICO in the last committee.
Well, let's stick to the questions. He's mentioned PERC a few times already
Okay.
in this
So,
committee.
thank you, Mr. Chair.
All right. Ranking Member Smith for a question, and then Rep. Joseph for a question, and then questions will be through. And then we'll move on to the amendment.
Thank you, Mr. Chair. Look, if Chair Byrd, if these unions are all using dues deduction right now, this is, I'm assuming, I don't know what the number is. Maybe you can answer this in your response. I mean, we're probably talking about tens of thousands and more of union members who are currently using dues deduction who would see a major disruption by your prohibition. The disruption is likely to cause a lot of chaos and obviously a loss of revenue for the unions as well. I think the question I have is just because we're all adults here in this committee and we want to be in possession of all the facts. The elephant in the room is that your bill impacts public sector unions who support Democrats in their political activity because of our support for those workers. So how do you respond to those criticisms, which we know everyone is asking themselves right now in the committee and in the public? How do you respond to the criticisms that you're targeting these unions as a political preference more than a policy preference, as you stated? I think we deserve an honest answer.
Rep. Hardy,
That's
inappropriate.
I would ask for decorum, Mr. Chairman.
Yes, please. Ladies and gentlemen, Rep. Hardy,
Mr. Chairman,
we
in
are all,
5 years in this
We are
chamber,
all-
I have never seen behavior like this from a member of the legislature. Never.
Mr. Chairman, I don't think finger snaps are a violation of decorum. I'm hoping that.
well, I'm going to ask that
Answer
we
the
don't
question.
have finger snaps over a question. Chair Bird, are you discriminating against any particular entity in your bill as far as the question that Ranking Member Smith posed to you? Yes or no?
No, Mr. Chairman.
All right. Rep. Joseph for a question.
Thank you, Mr. Chair. I want to circle back to Janice because I think we've already debunked your initial, assertion that that was the impetus. But when asked about that, when it was pointed out that the same agency fees that were at issue, which were the subject of the case, that happen in states like New York, New Jersey, Pennsylvania, and there are entirely inapplicable to Florida because we are a right-to-work state and have never before nor after the Janus decision ever charged such fees. You then identified that the First Amendment was an alternative rationale. So let's talk about that part, and I want to focus my questioning on the part about the 50% requirement before people are automatically just taken out of it. So under Florida's right to work state, which is found in our Article 1, Section 6 of our Constitution in Florida, which specifically states that the right of employees by and through a labor organization to bargain collectively shall not be denied nor abridged. So under Florida's current statutory constitutional protections, both at the federal level in terms of the First Amendment and at the state level in terms of Article 1, Section 6, preserve that right. So currently, you do not have to be a union to benefit from be a member of a union to benefit from that bargaining power. Under your bill and that section, it now basically addresses what was talked about in Janus, but on the flip side. So now you are presenting a constitutional issue there. So my question for you is basically this. I'm going to lay it out as clearly as I can because I too am also a lawyer and I too am also an educator. And that question is, currently under Florida's Constitution of right to work provisions that I just laid out, unions enjoy the benefits of membership. The employees in a bargaining unit do not necessarily have to be dues-paying members, but under your bill, in order to exercise that right to associate and to work or collectively bargain, now one must join a union to meet that 50% threshold. Is that correct?
You're recognized.
Thank you, Mr. Chairman. The right to organize is not the same as the right to have the organization validated. So we are making a policy decision that so under current law, a minority of a minority can form the union. And you're correct. That minority of a minority can speak for the entire bargaining unit. We are making a policy decision, a policy change, that if you're going to organize, that you should have, that the threshold should be 50% of the plus one of the bargaining unit to form the union. If you would like to suggest a different percentage, I'm all ears.
Okay. Members, we're going to move on to Amendment a 1. You're recognized to explain.
Thank you, Mr. Chairman. This is a technical change in lines, I think it's 77 and 78. So we changed the language to employee organization just to make the language consistent throughout the statute.
Very good. Any questions on the amendment? Do we have any public testimony on the amendment? None. Any debate on the amendment? Any objections to the amendment? All right. All in favor of the amendment, say aye. Aye. Opposed?
No.
Show the amendment is adopted. Seeing one hand, need more than that. Seeing three hands, we'll take a roll call vote. Tori, please call the roll.
Representatives Altman,
Yes.
Bartleman,
No.
Buchanan, Chambliss,
No.
Cheney,
Yes.
Drake, Fisher,
Yes.
Gianlombardo,
Yes.
Hardy,
Absolutely not.
Hinson,
No.
Joseph,
No.
McFarland,
Yes.
Mooney,
Yes.
Overdorf,
Yes, ma'am.
Payne,
Yes.
Roth,
Yes.
C. Smith,
No.
D. Smith,
Yes.
Stevenson,
Yes.
Toledo, Woodson,
No.
Zika, Nixon, no. Chair Masulo,
Yes.
15 yeas, 8 nays.
All right, by your vote, we'll show that amendment adopted. Now we are on public testimony for the bill as amended. And we have Ida Escamante, Florida Immigrants Coalition, waiving in opposition. Escamani. We have Ida Escamani from Florida Rising, waive in opposition.